Evening, everyone. On behalf of the members of the Planning Board and our professionals, I would like to welcome you to tonight's meeting of the Sparta Township Planning Board. This meeting is being held on Wednesday, June 18th, 2025, at the Sparta Township Municipal Building located at 65 Main Street in Sparta. Proceedings of the meeting are being live streamed on YouTube at www.youtube.com/@SpartaTWP. The time is 7:03, and this meeting is now called to order. Please note that no new business will be conducted after 9:30, and the meeting will end at 10. Please stand and join the board as we pledge our nation's flag. I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Dory, would you do a roll call, please?
Yes. Jeanette Burke, Ernie Ragsdad,
Here.
Brian Zimmerman,
Here.
Ron Day, Chairwoman Joan Furman,
Here.
Councilman Mark Scott,
Here.
Robert Bleakley, Vice Chairman Robert Otto,
Here.
Celeste Luciano,
Here.
Christine Dunbar.
Here.
Thank you.
Thank you. All right, the first thing on the agenda is the approval of minutes. We have two sets before us. One is April 16th, one is May 7th. And we're moving along, we're catching up with the minutes. I want to give a shout out to, she's not here, but a shout out to Molly Wildsmith, who's been helping out to prepare some of these minutes for us. So we're pretty caught up for 2025, except for maybe the last meeting or so. And then we're going backwards to 2024. In 2024, we still have 13 that are missing, and so she'll be working on them next. And I just had a question. We have 11 missing in 2023, and I'm just not even sure for this board, how many of us were here in 2023? One,
I think I was.
think or you know?
Yes, she was.
Two,
Ernie.
three.
That's sufficient.
Jeanette was
That
also
is
here.
And
That's
Jeanette,
sufficient.
so we
And Ron
are
as well?
able to go back and do them?
You are.
I didn't know how many we would
Once you
need.
set the quorum for the meeting, then those who are eligible to vote could then pass it. It's a statutory duty to have the minutes, so my professional opinion, even if you have three people, think of if you had people who have conflicts, technically if one person is there, you have a quorum, they can vote. So,
Okay, okay. So we'll be working backwards then. So hope you all have good memories. I just wanted to make sure and clarify that. With regard to the two sets of minutes that you have here, I just want to point out something. I was looking at the May 7th minutes, and I noticed that, one second here, let me pull it up. When it says that all present were in favor, it doesn't show the roll call anymore. And I think that's important because I did notice I didn't go back to the April 16th, but I did note changes in the May 7th minutes. So for instance, there was a motion made and seconded, and it lists, if you look at the roll call, 5 people voted yes. 3 were not eligible to vote because they were from 2024. So the December 18th minutes of 2024, Rob Bleakley, Mark Scott, and Rob Otto were not eligible to vote because they were not on the board at that time. Yet the minutes say all present were in favor. So I don't think it's a good indicator of that. And
Should actually say all present and eligible to vote, so that line was stricken out mistakenly. So we can change that.
but it still doesn't show who did the voting. So I think one time we talked about listing all of the people.
It's always better to have the names, especially when we're talking about the minutes when people weren't there. Just to clarify my other statement, so let's say someone has a conflict, as long as they are not stricken, they just abstain. They do create the quorum, and someone else, again, you just would need even one person to move it, as long as you have a quorum. So it is better for the sake to have their names. It's better practice.
You can follow it rather than having to go back to another set of meetings to see who was eligible. Because,
Historically speaking on those, if you don't mind, prior to this current board, that's how we did do them.
okay,
And it was asked to be changed. Excuse me, prior to, actually, it was Ron Day when he was chair. Ron Day had suggested all present in favor and then, or whomever is eligible. So this is a new board, so we can change it again. That's not a problem.
all right, because I noticed it a second time too, when it was approving the resolution 25-13. And it said all present were able to vote. Christine Dunbar was present, but then she said that she wasn't present at the meeting when the resolution for the green came up. So you weren't eligible to vote on that one, but it's reflecting as if she did vote. So it's very hard to follow.
I wasn't eligible to vote on the,
Right, it said you were recused,
Yeah.
it said Ron was recused, but
Right.
it didn't mention Christine. So I think if we just have
I would
the
do-
voting.
I would do
it-
a
it's much-
motion if this board, so Dory has direction, if that's what the board wants, that the minutes moving forward will reflect the names and voting pattern of the board.
I would put forth that motion if somebody would second it.
I'll second.
Thank you. And can we have a roll call on that, please?
Celeste Luciano,
Yes.
Ernie Ragsdad,
yes.
Councilman Mark Scott,
Yes.
Brian Zimmerman,
Yes.
Christine Dunbar,
Aye.
Vice Chairman Robert Otto,
Yes.
and Chairwoman Joan Furman.
Yes. So going back to the minutes as presented, can we make those changes?
Yeah,
Yes,
we-
of course.
Okay.
someone-
Yeah.
Someone move.
Move to approve them with the changes. Okay, so let's take the April 16th minutes first. Would somebody like to make a motion to approve the April 16th meeting with the changes to include the roll calls?
Can we add I like the footer on the May 7th. Can we add that to the April? You see that?
Easy enough, yeah.
All right.
Rob, what, the footer? I'm sorry.
At the bottom.
It's on the top, but it's,
It has page number and it has a link to the meeting so that it could be
They
cross-checked.
will have that. They all have that. when they
Okay.
post it.
All right.
Good comment.
all right. So approval for the what was it, April 16th?
I'll make that
minutes.
motion.
All right, in a second.
I'll second. That's Celeste.
Oh, yes, we need names. So Rob, Otto, let me see your green light.
Rob Otto, making that motion.
Celeste Luciano seconding. So since we're sharing, we're getting the same light.
All right, we have any comments, any other corrections to the minutes? Anybody see anything? Okay, can we have a roll call, please?
Ernie Ragsdad,
Yes,
Chairwoman Joan Furman,
Yes.
Councilman Mark Scott,
Yes.
Vice Chairman Robert Otto,
Yes.
Celeste Luciano,
Yes.
Christine Dunbar.
Yes.
Okay, and then a motion to approve the May 7th minutes with the changes?
I'll make that motion, Rob Otto.
I'll second Celeste Luciano. Actually, I'm sorry. I actually can't. I was not there for that meeting.
I'll second.
Thank you.
Ernie Reichstad.
Ernie Reichstad. Okay, roll call, please, unless there are any other comments?
Ernie Ragsdad,
Yes,
Brian Zimmerman,
Yes.
Chairwoman Joan Furman,
Yes.
Councilman Mark Scott,
Yes.
Vice Chairman Robert Otto,
Yes.
and Christine Dunbar.
Yes.
Okay, thank you. All right, today we have a special hearing. We are going to be presenting the 2025 Housing Element and Fair Share Plan and a resolution. And we have Catherine Sarmad and Matt Flynn here. Matt is the attorney representing the Fair Housing Plan, and Catherine has been the planner who has put a lot of this together. And I think, Ken, you need to swear Catherine in, and they'll give a presentation on the plan, and then the public will be free to come up and ask some questions. We're going to get all the questions at once, we'll take notes of it, and then in the end, Catherine will address those questions.
And just for the public, Matt is on our team. He works with Steve Warner, who is the special counsel on the fair housing. So Catherine, if you raise your right hand, do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Name and professional address for the record, please.
Catherine Saramad, and my address is 26 King George Road, Warren, New Jersey.
And you're a professional planner licensed in the state of New Jersey?
Yes, and my license is active and in good standing.
And you have testified before boards on fair housing plans?
Yes, I've been noted as an expert in affordable housing in multiple vicinages and in the affordable housing planner for multiple municipalities.
Board, I would recommend you accept Catherine as an expert in the area of professional planning with a concentration in fair housing.
Accepted.
Thank you.
I'll just do a brief intro to start and then turn it over to Catherine. As everybody knows, in 2024, the governor signed an amendment to the Fair Housing Act, establishing the fourth round of the affordable housing requirements that each municipality in the state of New Jersey has to adhere to. It's a constitutional requirement, as found by the Supreme Court in the Mount Laurel line of cases, that each municipality must provide a reasonable opportunity for affordable housing as part of the New Jersey State Constitution. And so a lot of you probably already know this, but around October of last year, the state gave each municipality a number of units that in theory they would have to zone for or create that reasonable opportunity. The Sparta governing body did adopt a resolution indicating the number of units that it found to be acceptable in compliance with the program. And before you today is a master plan element, the fourth round housing element and fair share plan. So like this board would do with any master plan element, the board must hold a public hearing in accordance with the municipal land use law, and it is actually the planning board who is responsible for adopting the plan. So if the board is so inclined, the board would vote on the resolution that should be in your packet that was circulated by my office, which would adopt the plan, and after which, within 48 hours, my office, who's been retained by the township as Special Affordable Housing Council, would file the resolution and a copy of the plan on the court docket. Every municipality, in order to demonstrate compliance, has had to file a complaint, a declaratory judgment complaint with the state in order to establish compliance. So Catherine has drafted the plan in accordance with her expertise on how to have the township meet its fourth round affordable housing obligation, again, to provide a reasonable opportunity for affordable housing within the township. The only other thing I'll add is that the current deadline for every municipality in the state of New Jersey to adopt its fourth round housing element and fair share plan is June 30th. The timeframes were very tight, and so we did provide the requisite public notice to the surrounding municipalities, the county, and the state in order to have the public hearing on this plan today. I found those notices to be legally sufficient and timely served and published, and such. When you hear about the plan tonight, you do have a legal opportunity to adopt the plan and thus demonstrate compliance with the next stage of the fourth round affordable housing legislation. And with that, I'll turn it to Catherine.
Thank you very much. So during this presentation, I will go through the document. I'm going to walk through it at a high level, provide some detail where necessary. I ask that you let me get through the whole presentation, then we can take questions at the end. So the plan is dated June 3rd, 2025. Again, this is the fourth round housing element and fair share plan element of the master plan. There are some sections to the document, so I'll kind of break up the presentation to those sections. So the introduction just sets forth the statutory requirements pursuant to the Municipal Land Use Law and the amended Fair Housing Act. There are a few additional statutory requirements that were added as part of the amended Fair Housing Act, which were largely related to how the plan is put together and what it needs to include, of which this plan does. The second section of the document is the housing element. So the housing element provides an overview of what Mr. Flynn just went through very briefly about the Mount Laurel cases that started back in 1975, Mount Laurel 1 through Mount Laurel 4, which was the 2015 Supreme Court case, and talks about the statewide history of affordable housing and how we've gotten to this point. Additionally, it mentions the fourth round, or the amended Fair Housing Act that was signed into law in 2024, which took this out of the courts where it was in the third round and brought it back to the state level through the amended Fair Housing Act, which abolished COA and established the Department of Community Affairs, the DCA, as kind of the body with the Affordable Housing Dispute Resolution Program as an arm of the courts, kind of assisting in this process for the fourth round. Additionally, this section talks about the Mount Laurel Doctrine in the context of Sparta, which was I thought very important because the original Mount Laurel Doctrine and the original Fair Housing Act did emphasize the role of the constitutional obligation in the context of conservation and open space and environmental constraints, which is incredibly important for Sparta in the context of the Highlands, and the various planning areas that have been designated in Sparta and the environmental constraints that exist here today. Additionally, it includes Sparta's affordable housing history, very briefly, and the compliance with all of the different Mount Laurel rounds thus far. And finally, gives a pretty good detail about the Highlands in Sparta, which portions of the Highlands, so there's different land use compatibility zones, of which there's various amounts of acreage in Sparta. Sparta is half in the Highlands Preservation Area, which is much more restrictive, and any municipalities that have preservation area must comply with the Highlands Regional Master Plan, and the other roughly half of Sparta is in the Highlands Planning Area, which still has some implications on development, but Sparta is not opted into the Highlands Planning Area, so it's less stringent than the preservation area. Finally, the housing element section includes, and it must include statutorily, an analysis of census data that talks about population demographics, housing, income, employment data, and other valuable point in time census information that discusses kind of where Sparta is today, looks back a few decades at some of the other decennial censuses, and analyzes them in that section. One other thing that is required, it was emphasized as part of the Fair Housing Act, amended Fair Housing Act in December of 2024. As I mentioned, there's this Affordable Housing Dispute Resolution Program that is an arm of the Administrative Office of the Courts. They submitted a directive in December of 2024, which set forth additional requirements that must be incorporated. One of them was an emphasis that municipalities, as part of this process, that receive interest letters from property owners or developers must acknowledge any of those letters that were submitted for any properties and discuss why a property was included in the plan or was not included in the plan. So property owners were allowed to offer their property or a proposal for a development that includes affordable housing to be considered for the plan. The municipality does not have an obligation to include any of those. It simply has to acknowledge them and discuss why it was or was not included. Sparta did receive 3 different letters of interest, one from a property owner at what is known as Crossroads at Sparta, behind Glen Road, so it's Main and Glen, offering to propose a 44 dwelling unit development with a 20% set aside, which would include a portion of property that is township owned that they would have to purchase in order to complete the development. Because there are constraints on the property, they would request that. Alternatively, they had offered that if the township did not sell the property, that they would offer a smaller development on just their property. But one thing to consider, and one thing that was noted in this plan, is that that site was included because those properties are already zoned MF3. They already permit multifamily housing, and they already require an affordable housing set aside. So the site was included in the plan under the MF3 zoning that already exists today. So no zoning is proposed to be changed as part of that, simply utilizing the zoning that exists today. Secondly, a site known as, or the entity is known as DDG. It's referred to in the plan as the DDG site, who is a contract purchaser. of certain properties known as Block 12008, lots 19, 20, and 21, sent a letter to the township requesting that their property, just to give context, it's the property across the street from ShopRite on Route 15, to be included in the plan. That letter proposed, and included a concept plan attached to that letter. It proposed 400 dwelling units, half of them being age restricted and half of them being family units, with a 15% set aside. There was subsequent correspondence that changed that to a 20% set aside on that proposal. The township did engage with that property owner to discuss the proposed letter, and there was a meeting in late May. However, there was a request for a lot more information regarding that property that was not submitted. The information that was requested and the reason for the meeting was to determine the site suitability as required in part of this document. Up until that meeting and thereafter, without the information provided in a timely manner, the site suitability analysis provided that the site does have environmental encumbrances in the form of wetlands and potential wetland buffers. The resource value of the wetlands was not delineated or known or made known. So it's unknown what the actual buffers from those wetlands would be. Additionally, the site is not in the sewer service area right now. And although there are sewer service areas around it, it is not included in a sewer service area. So there are limitations to infrastructure and sewer capacity, which is one of the requirements of a site suitability analysis is the site, does it have access to utilities and infrastructure such as water and sewer? So that was an unknown. We had made a request to see what the sewer capacity of the private treatment plant was across the street, if it would be allowed to join that, and if it would even be capable of doing that outside of a sewer service area without a wastewater management plan amendment before the NJDEP. Additionally, the township noted that the site is also within the planning area 4B within the state development and redevelopment plan. It's in draft form right now, but regardless, designated in that area on the state plan map, which is known as the rural environmentally sensitive area. That planning area has goals of maintaining the environs as contiguous areas of farmland and open space. It is goals to confine programmed sewers to the centers. So it talks about not expanding sewer service area in the PA 4B zone because of the environmentally sensitive nature. And so the township ultimately, without the information in hand to understand the site better from the property owner, the township found the site not to be suitable at this time and did not include it in the plan. Finally, the township received correspondence from Hakimian. They noted that they own block 10002, lot 61, which is the property across from the Stop and Shop, west of the Stop and Shop, at the Route 15 interchange. And they noted some specifics about their property in their interest letter, but did not discuss a specific proposal for their site. The township had already looked at that site, and not that site in particular, but the zone in particular, which that site is zoned, the Town Center Professional Business TCPB zone, already does permit a planned development, which includes up to 100 units with a 25-unit affordable requirement set aside. And so the township had already sought to utilize that zoning that's already in place as a creditworthy mechanism towards its obligation. So that while that site specifically was not included, the zone that already allows for it was included. That's just a kind of a formality. So that concludes the housing element portion of the document and feeds into the fourth round fair share plan. And the fair share plan focuses on how the township has historically complied with its Mount Laurel obligations and how it will comply with its current obligations into the fourth round. So there are different segments of the obligations as all of the rounds in the decades past are all cumulative. So they're not replacement obligations. They're all cumulative and on top of one another. There are kind of 4 parts to the obligation. The first being what's known as the present need or the rehabilitation obligation. Most municipalities have this present need obligation, which represents the requirement to basically bring older homes up to code. So they are probably in need of rehabilitation. The township has a 10-unit present need, has largely been in compliance with rehabilitations throughout the years. I think the township had completed 29 rehabilitations up to today. So as far as I see it, the township has complied and completed its rehab obligation. Not to say it won't do it anymore, but there's no obligation to do any additional. There is the prior round obligation, which ran from 1987 to 1999. The township's obligation there was 76 units, of which the township complied and had additional surplus credits going into the third round. There was a third round obligation, and this one's a little trickier. COA was invalidated, and the third round didn't happen as it was supposed to after 1999 to 2010 or so. And because of COA becoming defunct, that round did not resume really until 2015 when the Mount Laurel 4 Supreme Court decision came about, but it retroactively included it. So the third round runs a little longer than the other rounds. It runs from 1999 to June 30th, 2025. So we're still in the tail end of the third round, but that obligation was 377. And I'll discuss the township history with its third round, what happened in the third round, and where we stand. And finally, there's a fourth round prospective need, which will run for a 10-year period from July 1st, 2025 until June 30th, 2035. As Mr. Flynn had discussed, the DCA had set forth the obligations for every municipality that has an obligation. In October of 2024, the township did participate in the Affordable Housing Dispute Resolution Program to analyze the obligation that was set forth by the DCA which was an obligation 427, and to analyze that, set forth a number of 311, which was accepted by the dispute resolution program, recommended by the program judge in that program, and then accepted by order or set forth by order by the Mount Laurel judge in this vicinage. And so I'll talk about the prior round compliance first. The township had a prior round obligation of 76, of which it complied and, as I mentioned, had some units in excess of the 76, which then flowed over to the third round. Probably particularly because as COA was defunct, Sparta was still proactive and still had development going on through the early 2000s, which then led to additional credits that could be set forth to the third round. In the third round, because it was through the Supreme Court decision and it was done through the courts, the township, as well as many other municipalities, had participated in the process and was involved in a settlement agreement with Fair Share Housing Center. The settlement agreement that was executed in 2016 and the judgment of compliance reposed from the courts also in September of 2016 set forth that the 377-unit prospective need obligation was broken into 2 parts. And that was largely because Sparta had what's called a durational adjustment. The round 2 COA regulations permit that municipalities that have a scarcity of land can seek a vacant land what's called a vacant land adjustment to reduce their obligation. And municipalities that have a scarcity of water or sewer infrastructure or capacity pursuant to certain requirements could seek what's called the durational adjustment, which basically adjusts the number down to the ability of the municipality's sewer or water to accommodate that development. In recognition of the Mount Laurel Doctrine and the Fair Housing Act, which talked about the municipality's obligations in regards to those 2 limitations. So the durational adjustment set forth that the township's adjusted obligation was 251, and that its durational adjustment, so it set it to this, it set 126 units to the side and said, you don't have the capacity to do that. We can leave that be until or if sewer capacity is ever extended, sewer service areas are ever extended, or capacity is ever, investments are made into the sewer system that increase the capacity. And so that was all set forth in the settlement agreement, agreed to by Fair Share Housing Center, et cetera. The housing element from 2016 also discussed, and this plan incorporates much of the good information that talks about the sewer service areas, the wastewater management plan, the septic densities set forth by that wastewater management plan, and the limitations to the township's sewer capacity, particularly in the town center where it's most of the sewer service area is in the township. This also includes the durational adjustment requirements that's set forth in the round 2 COA regs, and it has the snippet from the 2016 settlement agreement that talks about the acknowledgement of the township's durational adjustment and why it was granted one. So acknowledging that since 2016, the township has not upgraded its sewer system. It has not expanded sewer lines or infrastructure, and sewer service areas have not been expanded or changed to new properties. The township still in this process and looking at the 4th round, looked at what other crediting or mechanisms had been completed during the 3rd round period from 2016 to today to see what was creditworthy, to see if any additional credits had been garnered, and to see where we stood in relation to our obligation. In doing that analysis, there was a few things that had changed. The Township Planning Board had approved an application that on Delmar Woodport Road that is called the Delmar, that included an additional very low income studio unit. So that was creditworthy and added to the plan. Within the town center overlay zone, which was implemented as part of the 3rd round housing element, there was a development on Sparta Ave that was approved under that overlay zone for an additional 6 units. And then, as I mentioned before, there are 2 zones that exist today, the TCPB zone and the MF3 zone, which were included in this plan as they are required to provide affordable housing. They provide the reasonable opportunity for affordable housing, and so they've been included as creditworthy mechanisms as well, in addition to what was included in the 3rd round settlement agreement. Finally, there are what's known as prior cycle credits. The Knoll Heights senior units are 100% affordable low-income senior units. They were not included previously. They were acknowledged in the settlement agreement that the township and Fair Share Housing Center agreed not to include them for some reason, did not elaborate why they didn't. It said the township had every right in future rounds to seek credit for those. And so the township, in seeking to evaluate what creditworthy mechanisms it has and how it could best reach its 3rd round obligation, included a portion of those units up to the age-restricted allowance in the 3rd round. And ultimately, where these crediting changes differed from the settlement agreement made up for the difference in the durational adjustment and utilized things that were all existing units, existing deed restrictions, and existing zoning in place to meet the 3rd round obligation. Again, no sewer infrastructure was upgraded. Nothing about the durational adjustment effectively changed. These were mostly existing mechanisms. And I will note that the TCPB zone and the MF3 zone are all within the sewer service area where there is limited sewer capacity, but they are in a sewer service area, which would make them more suitable. And there's a section on site suitability that discusses those sites. The one thing to note, or that was noted in this plan that may have seemed unusual, is that town center overlay that I just discussed, which was implemented by Ordinance 20-04, includes most, if not all, of the TC zones, the TCPB, the TCC, the TCCO, most of the TC zones are included in there. There has been discussion about a certain portion of the TCC zone, Town Center Commercial Zone, adjacent to Lake Mohawk, that is historic. It's on the National Historic Register. There have been discussions about the historic nature of those properties and that designation from probably 30 years ago in reverting back the zone to the C1H zone there. That would have no impact on that zone as it exists. It's simply, it would no longer qualify for the overlay zone there. So it would effectively be taken out. in looking at those properties and what's included there, I don't think any of them standalone would qualify under the overlay zone currently, because it does have a 2-acre minimum. So I don't believe it will have an impact, but it was discussed in this because it was a mechanism from the third round that was implemented, but it was just discussed to be perfectly transparent about the zoning there. As I mentioned before, the two mechanisms that are included, in some cases, when a municipality is doing a housing element fair share plan, it's required to include draft zoning that would be the implementation measures for a site. So if a site is not zoned for housing or affordable housing, it would have to include a draft ordinance. In this case, the zoning already exists in both the MF3 and the TCPB zone, so there are no draft ordinances to be included. The zoning exists. And so that concludes or wraps up the third round, and that the township has now fulfilled that third round obligation where there was previously a durational adjustment for 126 units. We can meet it with what we have, and with zoning in place on certain sites to make the opportunity for affordable housing there realistic. As far as the fourth round, as I mentioned, the township did work towards correcting the formula from the DCA, having the number recommended and ordered by the court judge to be 311, not 427. And as I mentioned, the durational adjustment sought in the third round, nothing has changed about the durational adjustment, which means that the sewer capacity and the sewer service areas have not changed since 2016, and therefore the ability to accommodate additional development in excess of what that capacity is has also not increased in any way, and therefore the township is seeking durational adjustment on the entirety of the fourth round obligation, as the sewer capacity simply is not there. Appendix A includes an analysis of the sewer capacity numbers, the flows. I did work with Mr. Simmons' office, with Corey Stoner, with Mr. Zepp, the town administrator, town manager, and the numbers are exactly the same as they were when we sought the durational adjustment in the third round. The reservations for single-family homes and existing approvals, such as the Fluss Holdings, are still exactly the same. So the sewer capacity, it's at capacity. There's no room for really any additional, which supports the durational adjustment. But a analysis of all the sewer service area properties that are within the township was included as Appendix A as a backup to basically, it's not a vacant land adjustment, but it supports the durational adjustment from a land perspective also. The only mechanism that is being proposed in the fourth round is what's called a mandatory set-aside ordinance. Most towns or municipalities were required in the third round to do something similar to this. Not exactly the same, but it essentially says that any property that comes in for a use variance before the zoning board, or requests a rezoning before the council, or a redevelopment plan before the council with 5 or more units must provide a set aside of affordable housing. It protects the municipality's ability, despite having fulfilled their past obligations, from having projects that proffer that they don't need to have affordable housing because the township is done with this obligation. I've seen it in other places. A developer will come in after a town's finished its plan and say, well, you finished your obligation, we don't have to do the affordable units, right? This would protect the town from being able to capture those affordable units at any point from any of those cases of rezoning, redevelopment, or a use variance, and would provide a 20% set aside of affordable units to capture additional. As I mentioned before, the planning board had requested that additional unit in that one planning board application, despite not having the mandatory set-aside ordinance for it, and was able to capture it. So this would actually enforce the ability for the boards to do that moving forward, if there are any applications that come before. But it is it is a way that other municipalities were required to do it as part of their settlement agreements. The only difference being that in the third round, many municipalities had a 15% set aside for rentals and a 20% set aside for sales as the second round COA regulations used to permit. Obviously now rental units are probably the more popular housing type that developers seek. And so it's my opinion that a 20% set aside across the board to capture as many units as these obligations continue to grow from a state mandate perspective, it's the best way and the easiest way for the township to capture additional units at a higher set aside. Other than that, the final section of the document includes a map that shows the various sites that are used to accomplish and fulfill the township's various obligations throughout the years. They are color-coded to show where or what rounds they were included in and what sites have been included and where they're located. As you can see, many of them are located around the town center, which leads to the next section of the plan, which there is a requirement now at the pursuant to the amended Fair Housing Act that the township, despite the state plan only being in draft form, provide a statement on the consistency with the state plan and how the housing element is consistent with that. The township does have a number of different planning area designations throughout it. Many of them are rural, environmentally sensitive, but they all particularly the environmentally sensitive ones, the goals that are stated in the state plan seek to avoid development and growth in those areas, and they prefer or they emphasize and encourage development to be in the other planning areas that aren't environmentally sensitive. And so the township has sought to continue to or follow the state plan recommendations, and most of the two sites that were added, the TCPB zone and the MF3 zone, are in the PA4, which is the rural planning area, which accommodates the growth in what was formerly the town center area, and still maintain the environs as large as open space without disturbing environmentally sensitive areas. So I did find that our plan was consistent with the state plan in that section. Finally, there are 5 or 6 appendix documents. As I mentioned, Appendix A is that durational adjustment. I just want to note that there was a typographical error. Some of the headers didn't update in my document, so I just need to change those. We might notice that. The township attorney did point that out to me, so I do need to make those for any kind of final version. I need to update those. The Appendix B is the spending plan, so every township is required that has a development fee ordinance and an amended and a spending plan is required to have a spending plan for the next 10 years. Regarding the Affordable Housing Trust Fund, the township does require a 1.5% development fee on residential and for any kind of additions or expansions on the change in assessed value, and a 2.5% fee on commercial development. And so that trust fund is utilized for things, and Sparta has used its trust fund to fund special needs projects, 100% affordable projects. It has used it for a lot of housing activity. It also allows for things like this housing element to be produced and to be expended for administrative purposes up to a certain limitation. And it has certain requirements that must be fulfilled for affordability assistance. As I mentioned, Sparta has done a wonderful job of utilizing it for rehabilitations, for special needs, for 100% affordable. So that has not been an issue. But this just sets forth a projection, and it's not exactly a budget because it does have very loose projections about what the township will get as far as additional funds to that, and how they will spend those additional funds, even though they haven't been collected yet. So it's not necessarily a budget, but it's a 10-year spending plan. Finally, Appendix C is that mandatory set-aside ordinance draft. It is draft. It is not adopted yet. That will have to be adopted by March of next year pursuant to the amended Fair Housing Act by the Town Council. It is a recommended ordinance, but it is subject to some minor changes. Similarly, Appendix D shows the minor changes to the TCC overlay zone that's discussed in the housing element. And then Appendix E includes any crediting documentation from the third round units that were not built at the time of the 2016 settlement agreement. So any units that were not certified through the court or the previous COA process, new crediting documentation such as deed restrictions were included in Appendix E. And then finally, Appendix F includes a little bit larger map than the one that was included at the end of the document to show the different sites and where they're located within the township. That is all I have as far as the overview of this document, but I do welcome any questions from the board.
Just want to say thank you very, very much for the thorough explanation. It's a very complicated subject, and we've had 2 executive sessions, very detailed executive sessions, and, you filled us in, and I think, we're all a little more comfortable with that at this point. But as you said, I would like to open up to the board before the public and see if you do have any additional questions on this. Anybody?
I just want to thank you, Catherine. Good job.
Thank you.
And for the record, there were at least one formal work session and informal work session, so no questions from the board should not be reflective that the board has not reviewed it and put time and effort into it. Thank you.
That's right.
Catherine, is the 20% set aside going to be applied to multifamily as well as for sale units?
Oh, so it will be regardless of tenure. So regardless of ownership versus rental, multifamily, whatever the development is, if it's 5 units or more, it will be a 20% set aside.
Okay, great. Thank you.
Anybody else?
I have a quick question, Catherine,
Mhm.
on, this is Appendix D
Okay,
and Township of Sparta ordinance.
okay.
And on the second page, Section 2, 1,
Okay.
I was wondering how it makes sense to increase the impervious coverage to 70%. How that makes sense and why that is allowed, yeah.
So this zoning ordinance actually, that's how it exists today. So this was not a surgical amendment to the ordinance. It didn't show the pieces that were changed about it. It shows the whole thing. So that's what exists there today. That was part of the third round settlement agreement. So those ordinance provisions are largely existing. It did take out there were other provisions about, I think, even higher impervious, up to 80%, 4 stories. Some of those were stricken from it, and it was kind of reworked into what you see now. So it actually is a little bit different, and I think more friendly to that development character of the area than it was previously.
Thank you.
Okay, if there are no other questions, we're going to open it up to the public for questions. And as I said earlier, we will first listen to all the questions or comments. Everybody will get sworn in. We'll record the questions, and then Catherine will answer them all at once. Okay, we ask you to be cognizant of time. We do have another application after this. So,
Sure. Do I just give my name or do I have to be sworn?
All right, so I am going to swear you in, but just for the public, you do not have to give your street address, just your name and if you reside in the town. But if you want to give your street address, you're welcome to, but you don't have to. Do you solemnly swear to tell the truth, whole truth, and nothing but the truth, so help you God?
I do. Jennifer Derricks, Tap Into Sparta. I just have a few questions. Some of the nuts and bolts, the demographic information leans on the 2020. It's 5 years old. Is that typical?
So those are just the last census, decennial census was in 2020. So that's the last hard census data we have. Everything else there is estimates thereafter. And some of them I actually think I just forgot to change the footnotes. I think they actually are 2023, but those are all estimated data because they just work off of projections.
Okay. Similarly, there's notes about using transportation census information or population projections. Is that typical?
So the NJTPA is the group that does regional analyses, and they were the group that provided that last study about employment and population projections through
Okay.
2050.
So that's something that's pretty ubiquitous through a lot of municipalities. So they're all going to use that type of data.
I think so, yes.
Okay, thank you. given the section you discussed at the end where we, talking about the proposed resolution for 20% set aside for multifamily and rentals of ownership or rental units, does the plan require, or is the township locked into the incentive zoning that Christine Dunbar was referring to?
So that's the only, currently, that's the only zoning we have that requires, or the only overlay zone that requires a set aside. No other zones in the township require that set aside. This would effectively make it so that anybody in any zone that benefits from rezoning, redevelopment, or use variance would have to provide that set aside. So right now, we don't have that on the books.
So I guess just to clarify the question, those two zones have incentive zoning.
The incentive zoning already requires a 20% set aside.
Right, so, but given the proposed, I think it is, resolution for the 20% set aside across the board, is that overlay, is that incentive zoning, are those incentive
No.
zonings required?
So it's not incentive zoning.
Well, no, the part that I'm talking about is incentive zoning in the TCC,
Yes.
all the,
Sorry, I'm misunderstanding.
with 70% or 80% impervious coverage, 2-acre minimum per 4 stories. So those are incentives that go above and beyond what's currently available to anybody else. So would that still be required? Would those incentives still be required once were those numbers?
So the reason why those were required as part of the third round settlement agreement, as I understood it, was most of those zones are already developed. They're developed with something else. And so in infill development, it was called an incentive zone for a reason, because they were trying to incentivize affordable housing to come there. I will say that in light of Christine Dunbar's question, I just want to highlight that some of those provisions that you just talked about, 4 stories and things, those were all changed. Some of them were changed as part of this proposed ordinance to be more realistic and to be more.
So they shrunk the setbacks and all of that?
Correct.
Okay.
Correct.
Or expanded the setbacks, I should say.
Correct.
Okay, thank you. Let's see. I think that's about it. Who, just as apropos to, I don't know what, who was the township representatives at the discussions with the 2 developers who submitted letters of intent? Or letters, I guess is.
The only meeting that I'm aware of was with the DGG site noted, and that was myself, Steve Warner as Affordable Housing Council, the Township Attorney Anand Dash, and the Mayor Neil Clark. Right, I think so.
And was that meeting documented?
I don't think it was recorded. It was a Zoom meeting.
Okay, so
Yeah.
there were no minutes or anything? of
No,
that meeting?
no.
And there was no such, a similar discussion regarding the property at the bottom of Glen Road?
I was not part of any discussions.
And to your knowledge, or to anybody else's knowledge, Mr. Porro, maybe, was anybody else part of that discussion? Maybe Mr. Flynn? Do you know? Not that you're aware. Okay, thank you.
Catherine, is there a way that we can eliminate that 4-story or that incentive zoning in the TCC zone in the town? Or do we have to
So
allow towers to be built in downtown Sparta?
The credits, or that has a line item in the third round obligation, towards the third round obligation. Right now, it's broken up into 2. Our third round settlement agreement accounted for 25 credits related to that zoning. Initially, the site where the Fluss Holdings was approved was a little bit more than what is approved for now. It was reduced. So I think it's now broken into 6 for the Fluss Holdings site, 6 affordable credits, and then 19 additional from the town center. So it does play a part in satisfying that third round obligation. But as I noted, it's included here as an appendix because it has been modified to remove the 4-story allowance. It has been modified. The zoning was looked at to determine if we could still achieve the 19 units in a 3-story product with less impervious coverage, with bigger setbacks. And that's what that draft ordinance includes. It strikes the allowance for a 4-story building, essentially.
How about a 2-story product?
I mean, someone could provide a 2-story project. This provides an allowance still up to 3 stories.
The
And-
TC
and that's-
incent, I'm sorry.
That's this document. Are you saying the third round? Is there a way we can change that now, is what I'm saying? Is it written in stone because it's in the third round,
It's not written in stone.
right?
It is substantially assisting in the crediting for the township's obligation. So it is right now accounting for 19 out of the 377. Actually, I think we're over 377. We're like 381. So give or take, there could be a few less units that are produced from that. But right now, it's just overlay zoning that allows. There are other requirements, like it must be a 2-acre site to even benefit from those incentives. So it's, in my opinion, in doing the zoning analysis for it, there's not many sites that qualify immediately. There's really no vacant sites that qualify immediately for the incentive zoning there. I will say that we'd have to do a deeper look at if we'd be able to meet the credits if we took that out entirely. But right now, it is satisfying. It is assisting in satisfying our obligation.
And that would that be a planning board or a zoning board or a town council obligation?
It's town council because it's an existing ordinance. Again, what I said before, these are draft ordinances. I don't think we should detour from them too significantly if it does go to council, because they are recommended through this master plan element. And so anything that's too different from them might be seen as not being consistent with the master plan element. But it is a recommendation right now to modify that zone as it exists today to be, like I said, more friendly to the context of Sparta. We've heard the feedback after the Fluss Holdings hearing and thereafter that zoning needed to be reanalyzed, and it was as part of this housing element.
Okay.
Thank you.
And just on the process, you are adopting a plan. Then it goes to the mayor and council to endorse the plan. But this is your plan. You set forth the concept. And then the mayor and council will then pass ordinances that are consistent with the plan. And that's why when we look at ordinances, we are reviewing them for consistency with the plan. Now, remember, the housing element is just one part of the master plan. And that's what we're talking today.
Just one quick thing, the incentive zoning came in 2020, which was post round 3.
No, it was during round 3. So round 3 ran from 1999 to the end of June of this year.
But I mean, it wasn't considered in the credits for, it came out of the
it
2019 master plan review.
The 2016 housing element and the settlement agreement included it. That's how the 2016 settlement agreement included the town center incentive zones as a mechanism. So when you go into the settlement agreement, you'll see the 25 credits for it that are associated with it. Thereafter, a master plan reexamination report was done, which analyzed all of the master plan documents, including that housing element that was done in 2016, and made the recommendation to then to effectuate the zoning that was required as part of 2016. So there was a gap in the time from the settlement agreement to when it was adopted, but it was a requirement of the settlement agreement, which is why it was included, or why the ordinance was redone in 2020 to effectuate what was required for those credits.
Okay, thank you. And Hakimian is vacant, so they would qualify for that.
Though the TCC zone has a specific line about the TCPB zone, which is it mirrors exactly what's in the TCPB zone, that the multifamily is up to 100 units with 25 units set aside. So that one is carved out specifically within the incentive, that still stands as what's allowed in the zone right now.
Okay, thank you.
Okay, anybody else like to be heard? I should have asked our professionals as well.
Taking the night off from affordable.
Too much affordable housing. Okay. Anybody else on the board? So we have a resolution that's before us to also adopt.
Yes, close to the public, please.
Okay. Would like to close this to the public?
So moved.
Would somebody make the motion to close it?
I'll make the motion to close it to the public. Rob Otto.
Second.
I'll second. Ernie Reichstad.
All in favor?
All in favor?
Aye.
None opposed. Yes, before you, you have a proposed resolution. I've just made some minor changes to it that I can just read in the record. On page 2, where it says, whereas after conducting a public hearing on June 18th, 2025, all I added after that was at which time public comment and concerns were received. That is an addition, and then I put comma. And after it says giving public notice, I just put after confirming public notice pursuant to the statute, the plan was before you. So my changes are minor. It's just merely on page 2, saying, adding at which time public comments and concerns were received. And I changed the word where it says after giving public notice to after confirming public notice. Those are the only changes, and I recommend the passage of the resolution as proposed. And, yeah.
Mr. Porro, I just have one question. I had noted some typographical errors. They're not substantive changes. I'm assuming that the board could still move forward, and the final document, once signed, sealed, put on file with the township, can include those edits.
So noted, and if you could, just on the issue of, on the acknowledgements, I've seen on other municipalities, if you could also note the town attorney on the township council, Mr. Warner's office as special counsel, and then the planning board, myself as the board attorney.
Will do.
Okay, thank you.
I had a question at the bottom of page 2.
I'll finalize it.
Where it says, "Be it further resolved that this resolution, the 2025 HEFSP, and any other required enactments be filed with the Superior Court no later than June 30th, 2025." Now, June 30th is the deadline, but our requirement, and this is our resolution, is that it is 48 hours after adoption. So should that read the 20th?
It's 48 hours after adoption or June 30th, whatever is earlier.
So it would be changed to June 20th?
Yes, it'll have to be within the next 48 hours.
Okay, so
My
I'd like
office
to
will
recommend
file.
that change.
All right, so the, again, as Matt and the chair, one point pointed out, we'll put here, filed with the Superior Court within 48 hours of passage. Matt, should we even say, but not later than June 30th, or just take it out?
I would say just within 48 hours of passage.
Okay, so be it.
Just as a reminder, there's a holiday.
We better move. Thank you.
Yeah, technically, the courts are closed for Juneteenth, so we're looking to file this tomorrow.
Yes, and I think Matt, I think you'd agree, in the court's in good faith if it's a holiday that's considered a grace period. I would think.
I would hope.
I would
File
get
it,
it filed
file
tomorrow.
it.
All right, you'll get it done. Good, good to know.
Okay.
Is there any reason that the durational adjustment is not noted in this ordinance?
Oh, in the
Resolution.
resolution?
Resolution, I'm sorry.
I think I stated enough in the report, but it's up to you if you want to throw it in there.
Yeah, I don't think because the plan is where the methodology comes from, I don't think the resolution has to be specific with the methodology of how we achieve the credits. As long as it says that the planning board feels that the plan satisfies the fourth round obligations and sets forth a little bit of the history, I think it's perfectly sufficient.
All right, great, thanks.
I would agree with counsel. Someone wants to move it with the
Yeah, I know,
changes.
I'm just saying if there's any other questions. All right, would somebody like to make a motion to approve resolution 2025-16, the resolution adopting the 2025 Housing Element and Fair Share Plan with the changes noted on page 2? both changes on page 2.
I'll make that motion, Celeste Luciano.
I'll second it, Brian Zimmerman.
Okay, may we have, is there any further discussion? All right, may we have a roll call, please?
Celeste Luciano,
Yes.
Ernie Reichstad,
Yes.
Councilman Mark Scott,
Yes.
Brian Zimmerman,
Yes.
Christine Dunbar,
Yes.
Vice Chairman Rob Otto,
Yes.
and Chairwoman Joan Furman.
Yes.
Thank you all for your time.
Thank you.
Thank
very
you.
much.
And Dory, you'll get us a signed copy by tomorrow morning?
Yes, I'm giving Dory
I
my,
will work on that.
I'm giving Dory my handwritten comments and then we'll circulate.
Great. Thank you all.
Is the office closed tomorrow?
Thanks.
No. Thank you.
Okay.
Thank you.
Thank you.
All right, how about we take a 5-minute break and then we'll resume with the next applicant?
Is that what it is?
Do I have to, all in favor? Aye.
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 Aye. Okay.
We're on.
Okay. Thank you. I'd like to welcome applicant PB 25-733 LJL Investments LLC, 40 and 44 Conestoga Trail. There is a typo on the agenda. It says LTL. It should be LJL. So with that, I'll ask our attorney to please swear in the appropriate persons.
Sure. Solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Name and professional address for the record.
Fred Stewart, Stewart, professional engineer and land surveyor. Office is located at 459 Route 46 in Kenville, New Jersey.
And just to cut to it, counsel, if you don't mind, what licenses do you hold?
Engineer and surveying.
And are they in good standing?
Yes, they are.
And have you ever testified before this board before?
A few years back, I have, yes.
And other boards
During
throughout the county
COVID,
and the state?
yeah,
And you would accept it as a professional in engineering, civil engineering and surveying?
numerous times throughout northern New Jersey.
I would recommend we accept this witness as an expert in civil engineering and professional surveying.
So accepted.
Counsel?
Good evening, Madam Chairman and ladies and gentlemen of the board. My name is Walter Hanley. The counsel for the applicant LJL Investments LLC. The L and J stand for Lisa and Joe Lefkin, and they're right behind us, just if anybody's wondering, right behind me, I apologize. The property in question is 40 and 44 Conestoga Trail, also known as Block 2010 in lots 90 and 91 in Sparta. The property is presently located in the R3 zone. The relief sought this evening is a minor subdivision where the two existing lots shall be subdivided into 3 lots, such that the new lots will be known as 38, 40, and 44 Conestoga, and that's per the report we received from the tax assessor. This evening, and by the way, like I said, all in the R3, and after the proposed subdivision, all be conforming, and there's no bulk variances required. This evening, I have with us Fred Stewart. I'd like to, been introduced and sworn in, so you could take us through the plans.
Sure.
Just for the record, Fred, your full name is Alfred,
That's correct. Full name is Alfred A. Stewart Jr.
as reflected on.
As reflected on the plan, I completed these plans. The plans I'm referring to or will be referring to are dated 3/10/25, no revision dates, and sheet 1 of 1. Okay, and that should be the plans that the board has as well. All right, so basically, we are here for a minor subdivision for lots 90 and 91, block 2010, also known as 40 and 44 Conestoga Trail. So lot 90 has 45,324 square feet within it. Lot 91 has existing area of 19,781.9 square feet. On lot 90, lot 91 is vacant. Within lot 90 is a 2-story home, along with a block garage that's detached, a driveway leading up to the garage. Formerly on the site were also 2 sheds that have been removed and an in-ground pool that has been removed. So those items are no longer within the property. And I would note that within one of your professional reports, or both of them, I believe, that there is a notation about a variance being required for one of the sheds. Of course, since that shed has been removed, that variance is no longer on the table, so we do not need to request that. So what we intend to do here is take those 2 lots and divide them into 3 properties, all conforming with the R3 zone criteria. As you can see on the bottom center of our drawing here, zoning requirements, zone R3, and we have the proposed lots. I will note this, that the proposed lots on the right-hand side are swapped. The 90.01 should actually read 90.02, and the 90.02 should actually read 90.01. I actually swapped those when completing the drawing. So although they are swapped, all the zone criteria is being met. As far as the lot area goes, the lot 90.01, which is on the right-hand side of the drawing, is going to be 15,813 square feet, which is conforming to the 14,000 square feet zone requirement. Lot 90.02, the center lot, the one with the existing home on it, is going to be 18,190.5 square feet. Again, that's conforming. And the proposed lot 91.01 is going to be 19,781.9 square feet. Again, that's conforming as well. As you can see on the drawings, the setback lines are show the building envelope, very large building envelope in place there. We have completed soil logs on the site, and we have done some preliminary layouts within our office to ensure that the septic systems we place properly on the site to comply with state requirements for septic design. Soil logs were satisfactory. We did 2 soil logs on each one of the proposed lots, including the one with the existing home, just in case we had to relocate that septic if need be. Since then, we have determined where the exact septic area is, which is to the left of the home. That does not need to be relocated, so really those soil logs were not necessary because we're going to maintain that existing septic. The existing home right now is served by a well, which is located on the right-hand side of the home, and we intend to be served by municipal water system, which is located right in Conestoga Trail for the water service. Now, I'd like to add that, as stated by our attorney, that there are no bulk variances requested or no use variance requested for this site. This is a conforming minor subdivision, and as you can see, and we will also be dedicating to the municipality 3,440 square feet of right-of-way area that's located within the Conestoga Trail right-of-way. Our deed actually goes to the center line, but just for Lot 90, that is, and we are dedicating that area within the right-of-way to the municipality. That's our proposal.
Is that in the, thank you, is that in the, because I have to do the resolution, is that in the documents, council? How would I refer to that? Is there a separate agreement? I'm just looking at how I can incorporate that in the resolution. Is there do you know, maybe your clients, is there a written document, or how's that?
As far as the right-of-way dedication, I reflected on the plan
Okay,
that there's going to be 3,440 square feet to be dedicated to the Township of Sparta for road purposes.
okay, so is the, that's nice.
Okay.
Is there a written document anticipated? Is it, David, how's that normally done?
Normally, excuse me, normally in a minor subdivision like this, Mr. Stewart would provide a meets and bounds description of that dedication, and it would be a deed to the Township of Sparta in fee.
So if, I'll just put, let's say in the resolution, applicant to provide meets and bounds with a deed dedication?
Yes, in fee. Because this is a minor, my assumption is the applicant's proposing to memorialize it by deed.
That's correct.
Okay, thank you. And I cut you off, so I apologize.
Okay.
Can you point out on the drawing where this set aside is, where this dedication is?
Sure, most definitely. This is the existing lot, Lot 90, right in this rectangle here. This is Lot 91, and that dedication is right along the whole frontage of Lot 90, this area here, which is 16 and a half feet wide by the length of the property, approximately probably about 210 and 220, somewhere in that area.
Okay.
That's that cross-hatched area across the front of the properties.
Why are you giving that to the town of Sparta?
Excuse me?
Why is that coming to the town?
Well, it's typical of a subdivision like this, when you have or a deed going to the center line of the right-of-way.
Okay,
That's what this does. We typically dedicate that area, which is the normal width of the roadway, in this case is 33 feet wide. We'll dedicate half of that roadway width to the municipality, which is normally requested by your engineer anyway, so we just went ahead and did it prior to
All right.
submitting.
Great, thank you.
And just for the board, that's a good thing, and the public, if the road is ever expanded, the property owner is giving their consent, and thereby there's no compensation. This is part of the condition of the approval. So it's a good thing for the town and the public.
It clears the title, I guess you can say.
Thank you.
Okay.
Are you done with your presentation?
Well, we have your professionals' reports,
Right.
if we'd like to address that. So I'll be referring to Mr. Simmons' report, which is dated May 19, 2025. He has numerous comments throughout. As far as the waivers that we requested, he's basically okayed them for completeness issues. As far as number 3, which is on page 2, Block 2010, proposed tax lot 9101. We agree with all the comments there. I don't know if you want me to go through line by line.
If the applicant is in agreement with it and the council, you can affirm. That's good.
Okay. All right, item 4. Yes, we are in agreement with that. As far as letter E, that regards the existing utility pole that's located inside of lot 90.01. We'll make sure that there's an easement for that to the power company. And as far as the overhead wires encroaching onto lot 90.01 that go to 90.02, we'll either grant an easement or most likely we will relocate those lines so they are coming in on their own property rather than crossing the new proposed lot there, 90.01. Okay, so we,
If the board understands, if you look at on David's analysis on page 3, talks about the utility pole and the overhead wires serving the existing dwelling. As the engineer pointed out, it can be resolved by way of relocation when any contemplated construction. So you could, to put an easement, to be candid with you, is a lot of work. I would think with the new construction, it could just be relocated. So I would recommend that it's relocated upon subdivision at the time of construction. But we'll continue.
we're going to relocate those. Okay?
Because then otherwise do an easement and to file it. Yeah.
No sense in having an easement when we don't really need it for simple relocation. Okay, number 5, same issue with that, with the overhead wires, but vice versa. So we'll make sure they're relocated. So the rest of those we're in agreement with as well. Number 6, yes, letter B, we went through already, which is the correction of the zone table for the correct lot numbers. And that should do it. Yes, we'll agree to the rest of those as well.
We can just go back to page 2 on the waivers. If you can just go through that, please.
Okay, page 2 with the waivers up at the top.
Waivers requested on drain structure within 200 feet.
Yep.
Waiver, Will, if you could.
Which begins on page
Top of
1
page,
as
yes.
well.
Oh, yes, thank
Yep.
you.
You're welcome. Yeah, so as far as that goes with the waivers, we do reflect with, I'm sorry, back up. This is number 4, which is on your checklist. I believe that's the number. This is regarding the key map showing entire tract in relation to surrounding areas within 1,000 feet of tract. We do have a key map on there. It doesn't go to a full 1,000 feet, but it's probably at around, probably about 600 feet. So we're asking for basically a partial waiver for that. Number 21, any existing and proposed easements. We are not proposing any easements, and there is not any easements on the property, but being that the utility pole is brought to light, we will be providing an easement for that to the power company. Number 23, location of all buildings, roads, and right-of-ways within 200 feet of property to be subdivided. We do reflect that on the key map. I'm not sure if that was meant to be on the larger scale, at 20 scale on what we show here in the main portion of the map. So we are requesting a waiver for that. Location of all telephone poles and identification of poles to be relocated if necessary. None are proposed to be relocated, just an easement provided for the one that's encroaching. Number 25, locations of all drains and drainage structures within 200 feet of the property to be subdivided. Again, another waiver requested. We do reflect all the drainage that's within our frontage of Conestoga Trail heading down towards Hunter's Lane. So that's basically the drainage that may be affected by this project, and that's what we reflect on the plan.
And David, if the new construction, the gutters would be sent to the street, is that part of is that part of construction code or?
I believe that the construction official will look at how the leaders are being handled. And Mr. Stewart did show existing drainage in Conestoga Trail, if in fact anything had to be tied into it.
Okay, number 27, locations of all existing wells and septic systems within 200 feet of the property. We do reflect the neighboring properties that are within the vicinity of our project that would be required by septic code to be reflected on our septic plans. That would be our neighbor to the north and neighbor to the south. We reflected the septic areas that were per the Sussex County Division of Health records. We pulled them off of there. Cannot do an Oprah request there. They say they're online. We go online, see what they have, and we reflect that on our plan. And that's what we did here. So,
Is it fair to say any new construction has to comply with current regulations? And so all three lots will have the most updated standards on septic?
that's correct. And we'll be seeking approval from this Division of Health, hopefully in the near future if this gets approved. Item 38, lot numbers indicated, new numbers to be assigned by the tax assessor, which they were. I believe the board has the report from the tax assessor, which is entitled Minor Subdivision LJL Investments LLC, with prepared by Joseph Ferraris, municipal assessor. Item 39, location of proposed driveway on municipal roads together with site distance profiles conforming to township standards. Requested a waiver for that. We're not showing any improvements on the properties right now, but we will be providing, excuse me, septic design and along with a grading plan for the vacant properties. And I'm sure that would be reviewed by the township as well. Item 40, if a corporation names and addresses of officers and stockholders. That one might be on you. That's a waiver. I don't know why.
It's in the application. But you need them on the plan. It's on the application. We'll put it on the plan.
Well, I have the owner applicant on the plan, which is LJL Investments LLC.
And counsel, just for the record, your representative, are they own 50/50 by your
Yes.
client?
Yes.
Thank you.
They were fighting about 5149. I had to walk away from that one.
Okay. So that should take care of the engineer's report, Mr. Simmons. Yep, now we have the planner's report.
Well, let's just see if Mr. Simmons has any further
Oh,
questions
I'm
on
sorry.
his report.
Okay.
For the board, I would say that Mr. Stewart and the applicant's attorney covered most of the items in my report. Just to highlight two other items, just so it's on the record, for both of the lots on the existing house lot and the proposed 91.01, I had called out for the hedges to be removed along the right-of-way line. Again, because there's going to be driveways coming out, Conestoga Trail is a relatively flat, straight tangent piece of roadway, but again, just to avoid any site issues, to clear them out.
Counsel, any objection to that? No objection. Good, thank you.
And that's the only other thing I had, Madam Chair.
Thank you. See,
I did have one question. There was maybe I missed it and you covered it. There's a well on the one property that's going to be capped.
Yes, if we get approved, we're going to tie the into municipal water with the existing home, and that well will be sealed.
Thanks.
From my own knowledge, do you have to seal it? I'm just curious. Can you use it for anything?
It's not mandatory to seal, but if you were to keep it and still hook up to the water system, there's plumbing code that protects, interconnection with that. And there's also the fact that you have to permit it to remain on the site for whatever purpose you keep it for. Can't fill the pool anymore, it's not there.
We
But,
don't want any cross-contamination.
Yeah, that's the main thing. Could still keep it for irrigation, but it has to be permitted by the state.
Thank you, both.
Okay, regarding the planner's report, I do believe we addressed everything within that report as well. One of the bigger things was the variance for the shed. Again, the shed has been removed. And, of course, the zone table with the incorrect numbering, which we will revise and fix. Both your professionals picked that up, by the way. Very thorough.
Okay. Do you have anything else?
That's all I have.
We have, oh.
The other
no
reports,
Other reports.
Yeah.
From the police, they had no issues. Same with Essex County Health, other than consistent with Health Department regulation. I believe there was one, Sussex, that was them.
2 more.
The Environmental Commission had no issues, nor did the Fire Department. Fire protection.
Board, I feel the applicant has adequately described the record and the documents before you. I have no questions.
Okay, anybody on the board have any questions? Christine?
I do have a question about, and this is on page 2, and this is number 25. And
Page 2 of which report?
of engineer's report, Mr. Simmons. I'm just have questions about the locations of all drains and drainage structures within 200 feet of the property to be subdivided. Waiver requested. So if they're not subdivided, then what does this increase the risk of flooding? Or I'm just wondering, is that an area that's prone to flooding? And do we need better drainage in that area? And you're asking for a waiver to not subdivide, which might, I don't know, it might provide better drainage.
This is just a waiver request to show the location of drainage within 200 feet. We do show the drainage within the frontage of the property and then some going down to Hunter's Lane, which is the flow of the water. So I'll just go to the plan. We show, as far as going up Conestoga, this would be to the south, to the left-hand side of the page. I don't think there's anything within 200 feet up there.
Uphill though, right?
That's uphill, correct.
Yeah.
And you're coming down the hill. Where frontage starts, there's 2 catch basins located directly in front of the existing home, right in the section here. And the one on our side crosses the road with the drainage pipe underneath the road. And then drainage pipe continues down towards Hunter's Lane to another catch basin, which then continues onto Hunter's Lane with another catch basin, and then goes down out that way. I guess that would be towards 181. But there is one other catch basin that connects to the one on Conestoga, right at the intersection of Hunter's Lane here. So the only reason for the waiver request is to not show anything else within 200 feet, because I do believe up this way there isn't anything anyway. And this one might be in the proximity of 200 feet, but there's no reason to show it, because we're not really affecting it at all. As far as any flooding goes, I haven't seen any. The property is fairly flat in nature, very slight slope going towards the intersection of Conestoga and Hunters. So as far as any flooding, I haven't seen it. I do not live there every day, but I have visited the site many times and haven't seen anything like that.
Just to follow along a little bit, but if the lots, okay, so you have lots, and if those lots were to be developed, that would create more impervious surface, and there could be more flooding. There could be flooding in that area, but you're confident that what is there now in place will handle runoff?
Yes, it will. And from what Mr. Simmons says, any of the grading, we will be directing towards Conestoga, okay? So this way it's not pocketed or going onto any other properties in the area. It'll be directed towards Conestoga, towards those existing catch basins.
Thank you.
David, anything on runoff from new construction, zero or no additional stormwater, or is that just commercial properties?
I think in this particular situation, they basically are going with the lot sizes of the zoning in the area. And presumably when Conestoga Trail was created years ago and built, they looked at the lot sizes and factored that into the sizing of the storm drainage system.
And then any new construction of the home has to comply with lot coverage and the like.
Exactly. To the best of my knowledge, the applicant isn't proposing, well, there's no home shown on here, but my assumption is that they're proposing, if they put homes on these new lots, that in fact, they'll meet the impervious coverage requirements.
And must meet all the zoning requirements also,
Correct,
setbacks and the like.
correct.
Okay, does anybody else have any questions?
I just have one quick question, actually more of a comment. Mr. Simmons had suggested that you remove the hedges from the right-of-way. If you would consider putting additional plantings to replace the ones that you're pulling, in other areas, obviously, just to consider it. Thanks.
Sure, we can do additional plantings on the properties as long as, you know, there will be room for it. From the layouts that we have already completed, just to make sure everything works properly, there will be room somewhere on the properties for some additional plantings.
Anybody else? Are you ready for a motion?
For public.
Oh, I'm sorry. Anybody from the public?
Just when I swear you in, you do not have to give your street address unless you want to. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Name and whatever town you live in.
I am Larry Dring, live in Sparta on Conestoga. Hey, just a few questions. Are they proposing a rezoning of the lots to allow multifamily homes, or is it still going to be single-family homes?
Single family.
All right. And did you require any waivers when you did the septic plan
We did
for
not.
those two other, for the two subdivided lots?
We did not submit for an application for septics as of yet. We have to wait for the lots to be created first. We will be doing that in the near future, I believe. And then when we do that, we have to follow state standards, so we cannot deviate with new construction.
Earlier, you had said there's going to be 3 new septic systems. So are you ripping out the old septic system?
No, we did 3 sets of soil logs for new septic systems if the one for the home was necessary, the existing home. At this point in time, it's not necessary to replace that septic.
Okay, so you'll be installing two new ones.
That's correct. 2 new septic systems for 2 vacant lots.
But if the existing home does certain, is it a bedroom or a bathroom that triggers a new?
Bedrooms.
Bedrooms.
Yeah.
Okay. So if the existing home is renovated and they put another bedroom, I'll leave it to the engineers. They go ahead, David.
If in fact, and when I did my site inspection, I saw they did a lot of exterior cleanup work, if you will, to improve the existing home. But it's an older home. And if they did in fact add an additional bedroom, Mr. Stewart would have to analyze the existing septic disposal system to see if the septic tank and the disposal bed was sufficiently sized for it. If not, they'd have to enlarge it or construct the new septic bed at that time.
All right. That's all the questions I have.
Thank you. Anybody else? Hi.
You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Okay. Name and town that you live in, if you want to give the address, it's up
Yeah,
to you.
Mike DeGatti,
Ivan Sparta. I'm the owner of the adjacent lot on Hunton. So I just had a couple concerns. I understand, well, first a question. It seems like this hearing is about rezoning those lots, not what's going to be built on them.
All right, it is not about rezoning.
Oh, not rezoning, dividing the lots.
It's just
you know.
dividing lots,
Yeah.
and they're coming with a variance-free application,
Okay,
which means that their compliance is compliant with local zoning.
Mhm.
They're single-family homes, and even though the one home has the home, the others do not,
Hmm.
those must be in conformity, or the new owners would have to come before the board.
okay. So there would be another process to get the building approved, the
If-
proposed
If
building.
the
If it's in
applicant-
variance
Yeah, if-
with their
If
rules.
the applicant sells the lot
Mhm.
and the person buying it has a fully conforming property,
Mhm.
they would get a building permit.
Okay, gotcha. So, I don't have a concern with the lots being divided. I have two concerns, though. One, as somebody mentioned earlier, and I'm sorry, I don't know who did, the drainage is an issue in that area. So the whole area runs slightly downhill towards my property. And just the way the house is set, it's an old house built in the 40s, all the water pools in the backyard. And I have a constant issue with it. I have foundation issues with it. So my concern is that adding a new dwelling right behind me with more impervious, surface area, would exacerbate that. So that's a concern I have. And the other concern,
Stop that one first. That's a fair question.
So I'm just jotting that down. All right, there's some things that we can do to help mitigate the situation as far as runoff going towards your property from this one during the construction process, and actually during the engineering process as well. We can put some things in place that could help that, such as a small berm along the boundary line, just either to divert the runoff towards Conestoga or basically to help block it coming onto your property up to a certain extent. We could do that, and then this way it'll basically, that small berm, if it doesn't cross over the berm, it could infiltrate into the ground at that point rather than travel onto your property.
Yeah,
So
I
there's
mean-
some mitigation that we can do. I can't guarantee that it's gonna be 100% all the surface runoff coming off our property, because that's the direction it's flowing now. But we will try and mitigate the situation to help you out with that.
yeah, no, that would be good because, as it is now, it's an open field, right? So, and as you can hear, we get a lot of rain. So it does rain a lot and there is a lot of ground saturation. So again, so these plans are not showing what's going to be built, not knowing what's going to be built and how the gutters and drains are going to flow and where the water's going to flow. If it gets pushed to Conestoga, I think it's fine because as you pointed out, there's a couple of big catch basins right there
Right.
that are designed for that. I think that'd be fine. My concern is that if that's not taken into account, in particular with the layout of the house and the design of the gutters and the drains, that would increase the water coming onto my property, which I don't think anybody intends to do, but it's a
Haley, is
concern
that
I
okay
have.
with your client?
Yeah. And the other concern I have is, and again, this is about the lot, not the building, but my house is kind of small. It's an old house. It's a remodeled cape. So, and the sun's always behind the house. So if the property to be built was the maximum height, it would block the sunlight to my house pretty significantly. So I don't, if that's a valid concern, I don't
Yeah,
know.
that would be a problem because we can't place a condition on the applicant that is different than any other person in town, just as you could raise your home. There's no variance, so that would be, it's called restraint on alienation, which means that you
Okay.
can't have discriminatory regulations
Gotcha.
on one property.
Okay. Well, those are the only
But
two
if they
concerns
went
I had.
an inch over the height, they'd need a variance.
Yeah, so the height is 35 feet. I don't think that's a big deal. I was imagining more like some humongous home. I don't think I don't think that's likely to be a concern. But it is in particular because, that lot is like to the south of my lot. So the sun's always in the southern hemisphere. So, I mean, it would be, if a big ugly house was built, it'd be an issue. But if a normal house is getting built, I don't think anybody has a concern. But the drainage issue is a real issue. So those are the two comments I had. Thank you.
Did you want to add a condition?
I
No,
had that, and the applicant agreed that on the.
no big ugly houses?
No.
Pick the color?
Hi,
Ms. Newmatter, Simon
Sure.
sort of told you nothing but the truth, so help you God.
I do. Jenny Derricks, Tap into Sparta. There's some very large old trees on the property. Is the intention to take them down?
I move that we're in bad shape.
Could you please, if you're going to address, you have to be sworn in, please?
Yeah, why don't you just, you're the applicant anyway. Simon swear to tell the truth, and nothing but the truth, so help you God.
Yes.
Name for the record, please.
Joseph Lefkin,
Joseph, do you live in town or out of town?
Lake Apagon.
And Joe, you're one of the owners of the property being subdivided.
Correct.
And you heard what was said here today by the engineer and the planner and by your attorney and your engineer.
Yes, sir.
And you and your wife are in accord with those conditions that were discussed.
Yes.
Now, there's a question before you as far as the trees.
Okay. So several of the trees have been removed that were dead. Two of the large trees were removed because they had branches cut off years ago and then filled with just cement, so they were rotting. So for safety purposes, they were removed. The two really large trees that are still there have no plans on removing those.
Now, just for
And
the
as
public,
far-
if there is no tree ordinance in Sparta, the new owners could do what they want to do. Okay, thank you. But this owner has no intention. Yes.
And on the part of what we're gonna build there, we're gonna build within what fits in the neighborhood. There's no reason to overbuild, and not make it fit the neighborhood.
Are you building it yourself?
Yes,
And you're going to live in one of the units?
I will not be,
So you're going to sell all three?
possibly, yeah.
And what's the intent on the existing home?
Rental for now?
Thank you.
Anybody else from the public?
So you're leaning forward, you're like,
Eh.
you solemnly swear to tell the truth, whole truth, and nothing but the truth, so help you God.
So help me God.
And name and,
Name is Pedro Julio Maderos.
you live in Sparta?
Yes, I live in Conestoga Trail. I've been a resident in the town since 2003. I can tell you the character of the town and our neighborhood. I feel that this subdivision of creating 3 lots versus just 2 will change the character of our neighborhood. I would argue before everyone, why 3? Why should our zone be only 14,000 square feet? Why shouldn't it be a consideration? When you consider other zoning areas within the town, when they build the different, when they develop an area, they made sure that there was those lots were much bigger, whether it be 2 acres, 5 acres of land, and considering any new construction. Our side of town is one of the oldest parts of town. So I think that's probably why there's only 14,000 square feet for the zone. But I just would consider, I think most of our neighborhood would not be opposed to seeing the 2 lots and building on that building new construction on that and allowing that to exist in that way. I just think that dividing it into 3 will just have a negative impact in our neighborhood. When you consider the Remax building and what that changed, the medical building, the other, another emphasis, another building was built up in that area of Conestoga Trail, just on the side of Woodport Road. We have seen dramatic change in our neighborhood. So just, I would ask the board, the planning board, to consider our neighborhood and its character.
I just add, I'm the board attorney, and I don't live in Sparta. They have a beautiful neighborhood, a beautiful town. When I drove by the property earlier, when you look at the lot sizes and what's conforming with the area, this applicant on the subdivision And it's similar to you can't put a condition on that, it wouldn't be a condition on you. So it's, again, you can't restrain the property with some type of alienation to it if it's fully conforming. So if the board was to say you can only have 2 lots, as the board attorney, I would say we're subjecting ourselves to liability because it's fully conforming with the neighborhood and the lots. This lot is, I drove by, it's a beautiful lot. It's one of the largest lots there. But right across from it, around it are smaller lots so therefore, even though this is, the 1 lot is going to 3, it's still fully conforming. So the board is hard pressed to deny an application which has no
I'd be on that.
variances or deviations.
Well, I would then ask the board to consider the environmental impact, or, for instance, the neighbor who's up against this, worried about water runoff. I've literally, one time, had my 1 dog run out. I was fostering a dog, and he went off into that property. And I felt so bad having to go on my neighbor's property, trying to chase my dog. It had rained hard, as you could hear some of the rain today. There was a lot of saturation, muddy, very muddy. My foot was sinking into the ground. That area particularly was to the back of the house, around the area where the pool was, but definitely around the back of the house, I could remember. The other thing I would consider, we drive on Conestoga Trail. The hedges, the way that the growth is, it cuts into the road. And of course, maybe the previous neighbor didn't manage that property so that the hedges wouldn't be so out into the road. So whatever is done up in the front there, you have to consider how it impacts, just regular traffic and also visibility. The other concern I would have is, where would the driveways come out? Would all 3 properties come out into Conestoga, that close to Hunter, to the corner? Or is one of them,
Look on the plan, it is, and Council, Ms. Hanley, they're all coming onto the street.
On Conestoga, yes.
Yeah.
And again, if you look at the neighborhood of the driveways of your neighborhood, and David, the requirement of the driveway, is there a local requirement on driveways?
Basically, one of the things that they look at is what is the steepest grade of the driveway. I believe off the top of my head, subject to checking, the township's limit for a grade of a driveway is maximum 15%. And the driveways going into these lots, because of the relatively flat grade, it's nowhere near that. Again, the other thing is, with regards to site distance, while we mentioned clearing out the vegetation, and perhaps as the board member mentioned, moving the vegetation back to restore some of the vegetation on the lot, we didn't want that to get in the way of the site distance for a vehicle exiting the lot, so they had safe vision up and down both ways Conestoga Trail before they pull out. But again, Conestoga Trail in this area is on a tangent line, if you will, and it's relatively flat. So I'm not foreseeing any problem with site distance, subject to getting rid of the vegetation.
do we know the approximate age of the existing septic tank and field for the existing home?
I believe it's about 20 years old, if I remember correctly. It was replaced, but I'm not 100% sure of the age, though. I would say somewhere around 20 years old. I
But
know,
they must comply with
Yeah.
the steps.
Right, with that. So if they felt that it was warrant to be replaced, then the state would be, whatever the regulations
It's
are.
not their call.
No,
It's
agreed.
the health department.
Okay, I was just curious, as I know they did proper testing.
And if you recall, the applicant agreed to a berm to make sure the water goes to the street.
Okay. And I guess the other thought would be the square footage of any of these houses, what were they anticipating?
As of right now, they're seeking no variances, so therefore, the municipal setbacks have to be complied with, and the height has to be complied with, and that creates the square footage.
I gotcha. So it could be somewhere from 1,400 or so. It depends.
That's over my pay grade. I don't.
Understand. Thank you. No further questions.
Anybody else? Hearing nobody else, I'd like to move to close. There is one more.
Just real quick. You saw me
Oh,
swear to tell
yes.
the truth, the whole truth, nothing but the truth, so help you God.
I
Name
do.
and address. for the-
Maria Maderos, I also live on Conestoga. I just wanted to let you know that most of the houses on that street and behind us are double lots. There are a few like mine that are not, but most people have double lots. That's all.
Okay, hearing nobody else from the public, I'd like to make a motion to close it to the public. All those in favor?
Aye.
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 The board, you have before you an application for a subdivision as set forth on the record. You had the plan of Mr. Stewart and his testimony under oath. You heard the representations of the property owner to comply with the conditions we talked about by way of the berm, the septic, compliance with the engineer's report, and the planner's report by way of just really technical corrections on the plan, more detailed on the engineering plan by way of relocation of utilities to avoid easements to the best, and that the hedge removal and best efforts as far as the hedges being removed in the front to have them moved back, similar or like natured ones, not within the right-of-way line of sight of the properties. That's basically what I have on my notes.
Okay, would somebody like to make a motion?
I'll make the motion to accept application 25-733 with conditions. My name is Christine Dunbar.
I'll second. Celeste Luciano.
Thank you. We have a roll call, please?
Les Luciano,
Yes.
Ernie Reichstad,
Yes.
Councilman Mark Scott,
Be clear, what are the conditions? Those are the conditions that you noted already, right?
Well, the conditions are set forth, most of the conditions were in the engineer's report. We discussed, because of the line of sight, the shrubs being removed, but best faith effort to replace them behind the line of sight, not in the setback area. The runoff to the street, full compliance on the new construction with regulatory construction laws. We also talked about the utility lines to be relocated, so there's no need for an easement, and addressing the utility pole, which may require a utility easement. That's all on David's report. And then also on the planner's report, there was some corrections by way of the plan that was acknowledged by the engineer. The engineer also set forth, the juxtapose on lot 90.01 on the chart should really be 90.02, but that was self-explanatory, and there was a representation they'll revise the plan accordingly. And I would think, council, the plan could be revised incorporating the comments of the engineer and the planner.
100%.
And then, just to add to that, the meets and bounds with the deed dedication?
Yes, that's the right-of-way is on the plan, and as David had said, it'll be a condition also, thank you, the meets and bounds of the right-of-way, and it is set forth well on the plan. It's 3,440 square feet, and it's related to a dedication for the Township of Sparta for road purposes. That would be a meets and bound deed dedication in fee, FEE, which is an ownership interest.
And the berm to mitigate the water runoff to the neighbor's property.
Correct, directing that berm runoff to the street.
Okay.
Does the board get another bite at the apple on the water condition at the time of building approval?
The board, it doesn't, but the town does. Because when the construction is built, it has to be built to building code requirements. Again, this is a single-family home. It's the most favored of community developments. So, the requirements are pretty straightforward, just as they are in any of the homes in the neighborhood.
But if there's a variance, then they would have to come back in front of the board.
They would
It's just-
normally come back before the Board of Adjustment.
In the building department, do they get a copy of all the conditions?
It'll be in the resolution. They will get that. The zoning officer would receive, let's see, the proposed plan on one of the new subdivisions. And Dory does an excellent job of looking, and the engineer and of the setbacks to make sure they're in compliance, and therefore no variance are required. They get a building permit. If there is a variance, they got to come back before a board.
What was the width of the berm? Is it spanning the 3?
I was just going to put the berm pursuant to the board engineers.
Okay, with that, Christine, would you amend your motion to include the additional
Or the clarifying comments.
clarifying? Yeah.
Yes, I will do that. I would like to propose that applicant, the application 25-733 be passed with conditions read by our attorney, and one being that our board our engineer will look at the berm situation and make sure that there will be the size of the berm that will mitigate the water flow.
Adequately, yes. Yes, adequately. The size of berm will
Adequately prevent, direct the water into the street away from neighbors' homes.
Good.
Celeste, would you like to
I
resecond?
will second that motion.
Thank you. We start with the roll call again?
Celeste Luciano,
Yes.
Bernie Reichstad,
Yes.
Councilman Mark Scott,
Yes.
Brian Zimmerman,
Yes.
Christine Dunbar,
Yes.
Vice Chairman Robert Otto,
Yes.
Chairwoman Joan Furman.
Yes. All right,
Thank
thank
you.
you.
Thank you.
Thank you for all of the comments from the public as well. We appreciate them.
Both, if you don't mind, both. You got time. Hey, Mike, you got time. I got you, yeah. We'll blame Fred because we need the meat and bounce. Yeah. Now, Fred, my father is Alfred and he goes by Al.
I don't know how that happened.
In there?
Okay.
I still can't believe you're stored engineering with the other stored engineering. Engineering.
Okay.
And my cousin has stored engineering.
That's so funny.
And they have to pay
Wow. All right.
Okay, other board business. I have something to bring up and hopefully you will all appreciate it. We don't have any applications before us for July 2nd. So I wanted to make a recommendation that we can take that day off.
I'd like that very much. And I'll first, second, and third that.
Okay. I don't know, do we need a
I
motion or
actually
just all in
thought that
favor?
when we set the calendar, we had already determined that, but maybe not, maybe I'm wrong. No?
We normally don't have it that week, but this past reorganization, it didn't work out that way.
Oh, okay. All right, then I'll second that.
All those in favor?
Aye.
Aye.
Okay, good news.
Record shows no opposed.
All right, we have some updates. Town council,
No, no update. We didn't
yeah,
meet.
you didn't meet. Okay. Environmental Commission.
Yes, thank you.
Christine, can you move that mic? Thank you.
Yeah, okay. So we've been busy as usual, and we did have our rain barrel workshop that was well attended. And I made my first rain barrel. Yes, I'm proud of myself. I do want to mention before I forget that we had two folks from the public. One was Gail Byrne from Lake Saginaw. And I know that she expressed that she really appreciated our salt watch monitoring because her lake is impacted by high levels of road salt contamination above the threshold of ecologically safe. So she expressed that. And then we also had another woman come, Tammy, I don't remember her last name, and she is an advocate of composting, of taking care of food waste within our community. And she says if they can do it in Brooklyn, everybody's required, we can do it in Sparta. And so she's working on this and reaching out to ANJEC and Sustainable New Jersey and other towns who have implemented such programs. So we'll be hearing from her again, I'm sure. I did let her know that that was one of the resolutions we're recommending that the town council pass. It's called the Municipal Food Waste Reduction Resolution. There's actually two bills in our state legislature. And the resolutions would encourage the state to start thinking about this and be serious about things like composting and changing permitting so that you can use your compost in your garden and doing the right thing, okay, by reintroducing organic matter rather than adding to our waste. So anyway, she was very happy about that, I think. And we also, just as a reminder, we have two other resolutions that we're supporting: Packaging and Paper Product Stewardship Act resolution and the New Jersey Climate Superfund Act that we're recommending. And these resolutions, if they're adopted by the town, the town is not obligated in any way. It just shows Trenton that we think these issues are important and we would like to see some action on them from you. So we're hoping our town council will seriously consider these and pass these three resolutions.
Have you asked for them to be drafted?
Oh, we have little examples for you.
Okay,
And you
thank you.
can, you know,
Okay.
tweak them.
Great.
Yeah. And we will be, by the end of June, we will be also reading, well, our chairperson will be making our annual report and we'll be approving that, and that will be available. And that's all I have to share with you, except for one other thing. We are, we're going to have a speaker on July 10th. All of you who have deer in your yard eating your plants, and if you don't, I don't know where you live in Sparta, but I'd like to know where that is, actually. We're going to have an NJDEP person come and help us kind of troubleshoot the areas and kind of set up a path towards mitigating this problem, hopefully, especially in the Lake Mohawk area. So that's our next speaker on July 10th. And we also are going to have a speaker very soon. I don't know, maybe Rob, you know when it is, but this is a really important one for the planning board, and I hope you all come to this. This might be before the July 10th. I doubt it. It's probably after. But this is all about preserving our land. And we're going to have the Ridge and Valley Conservancy, our local conservancy group, come and explain all about that and consider our new open space plan at the same time. So those are the two things coming up, I think, this summer for speakers. So I hope you can make it. Welcome.
Was just gonna look up that composting, Tammy Teller, and just to piggyback on there, she had mentioned it's the law in the city, and her initiative idea is to create a municipal yard waste composting site. Who's gonna collect it? Could we engage with local farms to help schools? And she obviously wondered zoning permitting issues, so she did show up. And then for minor site plan, we heard Messer, and referred that for full board review. The art project, new sign, we've asked that they conform to the ordinance, and the particulars with portable signage. Ivy Rehab, similar notes conform to the sign ordinance as stated for that zone. And then Tranquil Leaf, which we're sending to full board due to the nature of the proposed retail. And I think one other application came in, but I want to take a look at that.
Thank you. And then,
I'm sorry, does that mean you only have one pending?
Yeah. Leave it.
just came in today.
Unfair. Would have been done.
Okay, then.
Oh, well, and just having ongoing discussions about, I feel like we look at these applications kind of on a case-by-case basis, so I would love to kind of address some of the underlying design standards and inconsistencies across zones. So I don't know if the governing body, Mark, if you might be able to help us get a little traction. I know that the governing body would need to empower the planning board to look at that, but I can just tell you, I'm a little bit frustrated because I would like to really quickly review these applications and get comments and responses back to the applicants, but I feel like we could take a look and tweak the design standards, make them more universal, so, but it has to come from the governing body. We can't just decide, even though every application that we get, we're consulting these standards and just, so.
So maybe, Mark, if it's okay with you, that I would send a letter to the mayor and council requesting that the planning board be able to look at the design standards. There's issues on signage, there's issues on color, on lighting, that it makes it a challenge for the subcommittee, because if there were clearer design standards, as Rob was saying, you can check off, and I think Brian also, that this would just make that committee easier. So if it's okay with you, I think I would send a letter expressing the concerns and asking permission for the planning board to investigate.
No, I agree 100%. I mean, when you compare our ordinances versus some other towns' ordinances, theirs are usually much tighter than ours and clearer. So, yeah, that would be great. Thanks, Ken. And thanks.
It's thanks. Yeah, I mean, any support, because it's something that probably would be more properly done through the master plan effort, but we don't, I will not make it.
I think
to
it'll help the
18.
applicants as well.
Yeah, it's gonna
Mark,
have,
if we could say, okay, in town center, you know, X zone, right? Here's your standards, there you go. You know, C1H, here's your standards, there you go.
Yeah, and as you said, I mean, yeah, it's a master plan issue, but this is something that could kind of help the master plan
Yeah.
committee in identifying these even before we get to that point, because I agree, that's one of my biggest things I see in our whole thing is the inconsistencies throughout the zones on how we, the terms we use, all that. It should be consistent.
and I think it came up in the survey for the master plan, but I think, I like to think it will help, yeah, business owners, we can do a quicker turnaround. Those of us that are reviewing these applications, and I'm hoping also planning and zoning office, because they do a lot too to kind of try to make sure that we're looking at everything that might apply to an application. So, yeah.
And I think, looking forward, this is exactly what we're dealing with, is why you review your master plan a little faster than
40
our
years.
town has. And I think that's why we have the hodgepodge, because what we have is, we have addendums, and the addendums are written that aren't necessarily the same every single time, and getting it consistent across the board, so.
Yeah.
Awesome.
And in the surveys, Rob is right, it did come up, there was traffic and then there was something else, and then design standards was right up there.
Yep.
People wanted to see a look at the town.
I mean, if the design standards were consistent throughout all the zones in the town, that would really make the town look much more uniform and much more adorable, attractive. Yeah, I wholeheartedly agree with that.
I want to add to that. Town center, TCC zone, is a little different than ED zone. So you don't need the consistency from ED to be, the same standard as TCC zone. So, and that's kind of where our thought process is.
Yeah, no,
And at
agreed,
the end of the
but-
day, it's going to help the applicants as well.
But the terminology should be the same, and,
Yeah, yes.
I mean,
Yes, that I agree.
that's, yeah, I agree, there's different areas of town that have different
Mhm.
looks to them. I mean, Route 15 is not the same as Lake Mall Plaza, but on the other side of the coin, it just, like I said, terminology, that's the biggest thing, is we're
Not to mention, they're so convoluted that I had to put together a chart to say, if you're in this zone, you go to design standards, but then if you're in this zone, then you also need to look at these standards, and then if you're in another zone, you look at this, this, and this.
Right.
And people don't know where to go.
Yeah.
And with the White Deer Plaza thing, I mean, that's obviously, that came up with the affordable housing. But that zone as historic, I mean, there's also updates we can do that we haven't done. Previously, it was, signage should be natural materials. I think previously when it was a different zone altogether, it was must be. But I think that's something that could be adapted now with synthetic materials that have the look of natural materials. So this is another thing, like common sense update. It doesn't need to be natural materials, because just from dealing with some of these applications in White Deer Plaza, hey, why did you replace that sign with plexiglass? The other one was really nice. Well, it rotted. Okay, fair enough, but if we can achieve that same look with like a hardy or some other material, we should do that. But we need to get it we need to get it in there before we can recommend it.
What I would like to see eventually for the minor site plan committee is a video. Somebody to do a video, and to you could actually hold up, or you could show examples, for each of the zones, as they here would be something that we would recommend like this. And and also guiding them through the process, a little bit. Thank you for, welcome to Sparta. We're here to help you with your application process. And then just kind of take them through the steps and then hold up some examples or slides of examples of what is what we're shooting for, what we're trying to achieve in each one of these zones. And as you have the photo, tell them, suggest building materials or whatever else needs to go along with that. I mean, my heart goes out to them. They have, it's a lot of them, this is a very new process. And they're trying to do their best and move it through, but it's the terminology and everything that is a stumbling block to them. So anything like that that we can do to make it, a little bit more understandable will be more efficient for you and for everybody else, I think, and with the staff. Yeah.
I think we can at least get design standards in a graphical form, and that's something that we had talked about. There are some that exist, and I think also in prior master plans, Celeste probably would know better, but that each zone kind of has like a little intro that says, the overriding theme, I think, for Sparta is this like rural look, but then specific, TCC would be this and ED would be this. So I think we absolutely should have that. And rather than kind of having a hodgepodge, I'd like to kind of see it just as a logical stepwise thing, starting from most restrictive historic zones to, zones that are designed to accommodate business, like ED zone.
Actually,
So, yeah.
and the lighting would play into that. You'd have more of a soft light in certain zones. You'd have maybe a brighter light in other zones.
Yeah.
Yep.
And I think, Christine, to your point, I believe the Business Development Committee, subcommittee, was going to put together a brochure. That was the last I heard, maybe a month or so ago. Are you on that?
Yes,
Are they still considering that?
yes. There seems to be a lot of things that are in motion right now,
Okay,
and yes.
that would be great.
Yeah, that would be perfect for the business committee because they're involved in marketing and they would know how to do a good marketing video, to help our applicants.
And we're coming up on the 100-year for the Lake Mohawk area, 2027, so we should definitely have that represented, but probably video, not actual film.
Well, he's going to be George Washington.
That's true.
Are you?
Yes. Crossing the lake.
Across the Walken.
Sure, whatever. It'll be a
Okay.
quick show.
So thank you. We've got that covered. Anything else?
Just on the agenda, I'll have the resolution on the capital improvement. I wasn't at that meeting, and the minutes are now available, so I'll get that for you next meeting.
Okay, no problem. And then just the master plan subcommittee was the only other update. We met beginning of June. We have a letter that I just sent to Dory that the subcommittee approved. It's going out to all of the stakeholders. Thank you to Jenny for giving all the emails on that. So that will be going out in the next, whenever Dory gets a chance to do it. And then the leads will follow up and make the meetings, and they're to take place all through the summer and into the fall. And we also had a very good meeting speaking with Brian Intendola from Neglia regarding the circulation and transportation piece that we wanted to do. And we were originally thinking, well, let's just focus on the transportation vision piece, but he said what he was going to go back and do was create a hybrid. So it would have a piece of the circulation, a piece of the vision. What we liked most about the vision part of it is that he would go out to the community and the stakeholders himself. And he would have at least 2 meetings. He recommended October after the summer when everybody's back in school and you get a really good feel for what is happening. But he would do all of the data piece beforehand. So we should have that proposal back to us, he said, early next week. And we'll go over that and add that to the list of things that we are going to be accomplishing. So I think that's about it for now. And anybody else have anything? All right, who wants to do the time? Meeting adjourned? You're
About the
on.
public.
Oh, Jenny.
Jenny's still here.
Anything from the public? I look and it's empty, but. Thank you. All right, motion to adjourn? Bernie, you're on.
Motion to adjourn. Ernie writes that.
I'll second.
Who's seconding?
Celeste.
Celeste, all in